Canon 2 Propriety, Sections 21 to 30 under the Code of Professional Responsibility and Accountability. Section 21, Canon 2 Propriety. This talks about prohibition against gift-giving and donations. This section means that a lawyer shall not, directly or indirectly, give gifts, donations, contributions of any value or sort on any occasion to any court, tribunal, or government agency, or any of its officers and personnel. Section 22, Canon 2, Propriety. This talks about no undue advantage of ignorance of the law. This means that a lawyer shall not take advantage of a non-lawyer's lack of education or knowledge of the law. Section 23, Canon 2, Propriety, talks about instituting multiple cases and forum shopping. This means that a lawyer shall not knowingly engage or through gross negligence in forum shopping, which offends against the administration of justice and is a falsehood foisted upon the court, tribunal, or other government agency. A lawyer shall not institute or advise the client to institute multiple cases to gain leverage in a case, to harass a party, to delay the proceedings, or to increase the cost of litigation. Section 24, Canon 2, Propriety. This talks about encroaching or interfering in another lawyer's engagement and the exceptions of it. This means that a lawyer shall not, directly or indirectly, encroach upon or interfere in the professional engagement of another lawyer. Furthermore, this includes a lawyer's attempt to communicate, negotiate, or deal with the persons represented by another lawyer on any matter, whether pending or not in any court, tribunal, body, or agency, unless when initiated by the client or with the knowledge of the latter's lawyer. However, a lawyer may give proper advice and assistance to anyone seeking relief against perceived unfaithful or neglectful counsel based on the code. And now, Section 25, Canon 2 of the Propriety talks about the responsibility of a solo practitioner. This means that a lawyer in solo practice shall ensure that all matters requiring such lawyer's professional skill and judgment are promptly and competently addressed. Section 26 of Canon 2 Propriety talks about the definition of a law firm and the choice of firm name. Now, as defined, a law firm is any private office, partnership, or association exclusively comprised of a lawyer or lawyers engaged to practice law and who hold themselves out as such to the public. Now, in the choice of a firm name, no false, misleading, or assumed name shall be used. The continued use of the name of a deceased, incapacitated, or retired partner is permissible, provided that the firm indicates in all its communications that the said partner is deceased, incapacitated, or retired. Now, Section 27, Canon 2 Propriety, talks about a partner who assumes public office. So, when a partner assumes public office, such partner shall withdraw from the firm, and such partner's name shall be removed from the firm's name unless allowed by law to practice concurrently. Section 28, Canon 2, Propriety, talks about dignified government service. Now, lawyers in government service shall observe the standard of conduct under the Code of Professional Responsibility and Accountability, and also the Code of Conduct and Ethical Standards for public officials and employees, and other related laws and issuances in the performance of their duties. Any violation of the CPRA by lawyers in government service shall be subject to disciplinary action, separate and distinct from liability under pertinent laws or rules. Section 29, Canon 2, Propriety, talks about lawyers who were formerly in government service. Now, a lawyer who has left government service shall not engage in private practice pertaining to any matter before the office where he or she used to be connected within a period of 1 year from his or her separation from such office. Justices, judges, clerks of court, city, provincial, and regional prosecutors shall not appear before any court within the territorial jurisdiction where they previously served within the same period. After leaving government service, a lawyer shall not accept an engagement which could improperly influence the outcome of the proceedings which the lawyer handled or intervened in, or over which the lawyer previously exercised authority while in said service. And finally, Section 30, Canon 2, Propriety. This talks about no financial interest in transactions and no gifts. This means that a lawyer in government shall not directly or indirectly promote or advance his or her private or financial interest or that of another in any transaction requiring the approval of his or her office. Neither shall such lawyer solicit gifts or receive anything of value in relation to such interest. Such lawyer in government shall not give anything of value to or otherwise unduly favor any person transacting with his or her office with the expectation of any benefit in return. So that's it, sections 21 to 30 under Canon 2 Propriety of the Code of Professional Responsibility and Accountability. Thank you for listening.